Hi, welcome to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me, as always, is co-host Sam Kill, Senior Associate at MBK Chapman. Good morning, Sam.
Morning, Mike. How are you today?
I hope you had a great holiday.
I did. Fantastic.
Good.
Yeah.
Good.
How about yourself?
I did. Thanksgiving was great. Food was good. Everything was great.
Glad to hear it.
Today, Sam, we're going to, and we always seem to start the same way. We talk about something this is critically important or it's really important. That's because we try to talk about things that are important in our podcast, not things that are trivial.
That's right.
So here's another very important issue. It comes up every day because it's just part of life when you're dealing with directors, when you're dealing with any kind of organization, whether it's a corporation or whatnot, that has a group of people representing other people, you're going to have potential conflicts of interest.
Yeah.
So today we're going to talk about conflicts of interest in the context of an HOA. We're going to talk about the definition of a conflict of interest. When is a director conflicted under the law? And once they're conflicted, what are their obligations? And then what you as homeowners can do to recognize if one or more of your directors has a conflict and isn't doing what they're supposed to do under the law. Because that's a big, big deal. Because conflicted directors, when you have a conflicted director voting or participating on things that materially benefit them personally, that's a real problem. It's an ethical problem, really, but it's also a fairness problem. And it's a direct pathway to corruption. And that's why the law is very specific about what can and can't be done with respect to directors. And when they're wearing their director hat, they have to abide by certain ethical regulations and rules so that they don't find themselves in conflicts of interest. So that's really the topic today. We're going to talk about what is it legally speaking, what's a conflict of interest? How does it show up in real decision making in an HOA? What the law requires? What homeowners can do to uncover it and recognize it? And then what do you do once you've done that, or how do you go to prove it?
Yeah.
Which are both kind of the same thing, two sides of the same coin. So let's start with a legal framework, okay? What is a conflict of interest? Well, in very simple terms, a conflict of interest is a situation that arises when a director has a material financial interest in the decision being made by the board. A material personal financial interest, okay? And we'll get into examples a little later in the show, so I won't go into them right now. But in the easy examples, it's very easy to spot.
Yeah.
Okay. There are situations where it's a lot more subtle and requires a little bit more discernment. But for the most part, I would say in the vast majority of situations, conflicts of interest are going to be the obvious conflicts of interest. Okay. They're going to be easier to spot. All right. It doesn't have to be dramatic. In fact, this is an issue that goes unnoticed most of the time, because people just aren't programmed to think this way. And unless you're looking for it or you know what to look for it, you just won't spot it. And so it's extremely pernicious as well. And it does erode away at the foundations of the whole point of the openness and the transparency that's inherent.
Transparency, absolutely.
In the Davis-Stirling Act. So exactly. Conflicts of interest don't have to involve embezzlement or stolen monies. It doesn't have to involve specific evil doing on the part of the director.
Right.
It can be oversight. It can be innocent oversight. It often isn't, but it can be. It often is. Okay. I would say it's probably more often innocent than not. But the problem is it doesn't matter because the end result's the same.
Right.
And so you've got to nip it in the bud whether it's innocent or not. That's the problem. Okay.
And mistrust, it may can actually have tectonic effects too, where people may wrongfully attribute, let's say, a fraudulent scheme or malicious intent, and you don't want that in a community where these people, trying to get along and get things done.
The thing is that conflicts of interest doesn't have to involve malicious intent or fraud or any of that.
Yeah.
It can be, as we just said, innocent. Yeah. But the look of it. Okay, how it comes across.
Bad optics.
That's the one. That's the word I wanted. I was looking for optics. Okay. So there are two sets of laws that touch on conflicts of interest for purposes of our discussion today. The first will be found in the Civil Code, which is going to be under the Davis-Stirling Act itself. And the second will be found in the Corporations Code. So I'm going to start with, since all HOAs in California are governed by the Davis-Stirling Act, I'm going to have Sam start with the code section in the Davis-Stirling Act that specifically applies to board-related conflicts of interest. Go.
So under the Davis-Stirling Act, Section 5350B specifically dictates that conflicted directors must abstain from voting on matters where they have a substantial monetary pecuniary benefit in.
So
right?
financial benefit.
Financial benefit, exactly. So that's, to be clear, abstention. So that's, they shall not vote in those matters.
That's right. And we're going to get into why he's, in a minute, when I talk about the Corporations Code, we're going to use another word, and we're going to talk to you about the difference between those two words and why he specifically chose the word abstention. So when you abstain from something, you're just not voting.
Correct.
You're staying out of the vote. So if there's 5 directors and one of them is materially involved, and this, one of the examples we'll cover in a few minutes is, let's say this specific issue affects money, a decision to spend money on this particular person's unit, okay? This conflicted director should step out of the vote, meaning that there won't be 5 directors voting on that for a majority, right? It could be 4-1, 3-2, whatever. It won't be that. It'll be 4 of them voting, okay? So you are having one person step out. They are abstaining from the vote, okay? So that's under the Davis-Stirling Act. And the Davis-Stirling Act says in the event of a conflict of interest, the director involved, the one that's conflicted, must abstain. Great, no problem. Easy to understand, okay? Now, there's this other rule, and it's called recusal, or this other word, I should say, that's called recusal. When you recuse yourself, you are not just abstaining from the vote. You are stepping out of the discussion involving the vote. Most often, you're leaving the room. Now, technically, you could be recused, but sit in the room as long as you don't say a word and your mouth is zipped. But that's not how it's supposed to be done. Most of the time, for purposes of transparency and clarity, the director should actually step out and not be part of the discussion. So if this is a discussion that is appropriate under executive session, for example, the director, while normally present during this executive session meeting, would step entirely out of the room and wait in the hallway, okay? Or if the entire discussion was based on this one decision, not even show up, okay? So as not to influence the tenor of the discussion, the direction of the discussion in any way whatsoever. Now, it goes without saying that person shouldn't also be sending emails saying, hey, vote this way, or hey, vote that way. That shouldn't be happening, okay? And, of course, the person is not going to be, when you get to the open meeting and you vote for yes or no, that person must also abstain. Okay. Now, that's when we get into the Corporations Code sections. 310 and 7233 are the 2 Corporations Code sections that apply. And they basically state that when a director is conflicted, the director must recuse him or herself from the discussion and abstain from vote. Now, why am I, and I'll go so far as to say this. The Corporations Code goes into more detail than the Davis-Stirling Act does. It actually talks about the standards that are required. So in the event of a conflict of interest under the Corporations Code, the conflicted director has to disclose the nature of the conflict. Again, sometimes it's obvious. They're voting on, and we'll get to these examples later, but they're voting on whether or not to spend money on his or her unit. But that's not one where the director would be tasked with having to disclose the conflict because everybody's aware of the conflict by nature of director lives at this address and we're talking about this address. But let's say they were open bidding for some sort of contract, for some construction work, and the director's brother or wife or even the director owns one of the bidding companies. That would have to be disclosed to the board saying, hey, by the way, I own this. I don't want to get into details because we're going to get into it when we get to
this actually happens quite a bit.
It happens all the time. We're going to get into that in a few minutes. But that's when the director would be obligated under the Corporations Code to disclose the nature of the conflict. 2, to step out of the deliberations. That's recuse. Okay. 3, abstain from the vote when the vote eventually happens. So that's abstention. And then 4, the other disinterested directors acting in good faith would have to make a good faith decision as to whether or not to vote yes or no based on what's best for the HOA, not what's best for their buddy, their pal, their best buddy, BFF, none of that. Okay? That's the requirements of the Corporations Code. So why the difference? because there seems to be sort of a conflict here. On the one hand, Corporations Code has those 4 requirements, recusal and abstention, and the Davis-Stirling Act, on the other hand, only has abstention. Is this a conflict? No, it's not. It's a recognition that just because the vast majority of HOAs in California happen to be mutual benefit nonprofit corporations doesn't mean they all are. There's no requirement. Notwithstanding what there's another HOA or homeowner side law firm out there with a podcast, and their managing partner actually published in that person's book a straight out misrepresentation of the law by stating that all HOAs in California had to be incorporated. That is not the case. They don't have to be. Most of them are. It's a good idea to be, but they don't have to be. But there's a recognition there of that fact. So to the extent that your HOA is a corporation, it's subject to both the Davis-Stirling Act and the Corporations Code. If your HOA is not a corporation, it's subject to the Davis-Stirling Act, not the Corporations Code. So there is no conflict here. To the extent your HOA, like most is a corporation, you have to do both. So what would that end up being? It would end up meaning that you would have to recuse and abstain. Whereas if your HOA is not a corporation, all you'd have to do is abstain.
Right.
So technically, I guess you could be involved in the vote or discussing of not the vote, but discussion of that, but just abstain from the actual vote itself. So you could be part of the discussion. You could lend your weight, what you think should happen, but then when it comes time to actually vote, you close your mouth, that's the abstention. Whereas Corporations Code's got a higher standard. It's recuse and abstain. Leave, don't be part of it, and, oh, by the way, you don't get to vote either. Okay?
I mean, needless to say, the far safer standard is the recusal standard.
Even if, exactly.
You remove any doubt, any potential fog of doubt.
And why is that important? Why is that important?
Because of transparency, because of the true nature of perhaps the arguably the top duty of a board member, which is their fiduciary duties of loyalty and standard of care.
Exactly.
And
which we have a podcast on.
We do.
Relatively recently. The entire thing's on fiduciary duty.
Right.
And you're very much right. So let's assume for a minute, because this is what Sam is really saying, and correct me if I'm wrong, but what I think you're really saying is, let's pretend just for a second that your HOA is not a corporation. They should, even though not required, they should still recuse and abstain.
That's exactly it. Yeah.
Even though the Davis-Stirling Act only specifically states abstain, for the purposes of transparency, to avoid the appearance of an impropriety, not just to avoid the illegal impropriety, but to avoid just the appearance of an impropriety, recusal and abstention is better. I agree. But it's not required. And what we're talking about here is what the law is. And the law does not require that. Now, if you're a corporation, if your HOA is a corporation like most are, it does require that.
It does.
Okay? So there is no conflict. There's a recognition that not all of them are corporations. Okay? And that's all that is. So that this I guess leads beautifully into our next section. Sorry, give me my fault. My throat's getting dry. Which leads beautifully into the next section is, what are some examples of the kinds of conflicts that arise in an HOA? Okay? So I'll lay out a broad category and give me one or two examples from that category if you can. All right, Sam? So most often, and I think you mentioned a minute ago, a lot of this stuff happens more than people might think.
Yeah.
Okay? So we're picking the most common ones. We're not discussing all the potential ways that this manifests in an HOA. We're just going to talk about the ones that happen pretty frequently. Okay? And again, they happen in bad HOAs because good HOAs, conflicts happen everywhere. All right? They happen in every HOA, stellar, incredible, or terrible, or HOAs from hell. But how the board treats those and deals with them is what makes an HOA a good HOA or an HOA from hell. And that's kind of what we're talking about. How do these manifest in real life? Well, vendor contract misconduct. You have an example of that. Of a typical conflict that arises in that arena.
Yeah, I mean, you alluded to this earlier, and I encounter this quite a bit, surprisingly, in my both consultations and actual clients I work with. And this is really where you have a close family member, could be a son, a daughter,
yourself,
a sibling, or yourself, and they're either affiliated with or actually have an ownership stake in a construction company, work with contractors, developers, etc.
Right.
And they retain these guys, just to do the work not only limited to their own home, but to the community as a whole.
The community is hiring them to let's say you have a landscaping business,
right.
and you're looking at a huge contract, and let's say you have a large HOA with a few hundred units. You have a tremendous amount of landscaping, and it's a contract that they award every year, and you're even if you're taking bids from others, but in many cases, there's no bids. It's just this one company.
Yeah.
And and the director that owns it, or the family member or his best friend owns it, doesn't disclose that at all. Nobody knows. That is a massive conflict of interest.
Huge.
And if this director were to not disclose the conflict, that person would be completely violating the law. And of course he would, or she would. Does that make any sense for that to be remaining a secret? No. Everybody that's listening to this podcast or watching this video is shaking their head no, because it's obvious that that's wrong.
So obvious. Yeah.
It's not wrong that the company eventually gets hired if it's qualified and it's got the best price, it can beat the other people, apples to apples comparison, then it should be hired. But it should be done with eyes open. Everybody should be aware. Right. Certainly the directors making the decision should be aware that director number one over here, Bob, happens to own this company, or Bob's brother, or Bob's best friend, or whatever.
In an instance where it is apples to apples, let's say the workmanship, track record, all of those things, right? No derogatory history when you look them up with the CSLB, et cetera. And they have adequate insurance. And when that decision is made, if you have recusal, where this person is not even exerting undue influence on the other board members.
He's disclosed the issue and then stepped out.
Or there's no chilling effect on them actually deliberating and discussing things fairly, right? Even though they're apples to apples.
Well, let me interrupt, because what you're saying goes to this last point, which is, in the absence of competitive bidding, you get the situation with competitive bidding, you get into the situation you were just alluding to, which is there's nothing wrong with selecting that company if it's apples for apples. And there's some sort of bidding process which allows non-affiliated companies to get the same contract. In other words, if the HOA says, we're going to award, thank you for disclosing that you own it, step out. We're not going to look at any other companies. We're just going to hire yours because we like you and you're our buddy. That's still a problem for me. Because remember, it's not just the disclosure of the conflict. The fiduciary duty of the directors to also act in the best interest of the HOA, not the best interest in their buddy, old pal Bob, whose best friend, wife, brother, son, or himself or herself owns that company. So you can't pick Bob's company or Mary's company if that company is 25% more expensive than every other contractor. And how would you know that without having a competitive bidding process?
Here's the reality, though. When you're dealing with these HOA boards, people are people, ultimately. They are rather cavalier with these things. They're very casual.
They're corrupt.
And corrupt. And they feel this in this case, a misplaced sense of loyalty to their neighbor, to the other fellow board member who has a vested interest. And so that unfortunately happens more often than you'd like.
And that's why, that is exactly why, because human nature being what human nature is, and psychology being what psychology is, and people being who they are, in many cases we suck, okay? It is why the transparency is so important, so critical, so absolutely important to get over the fact that sometimes, notwithstanding the conflict, it's okay to do that. But they've got to make good faith efforts to avoid the trap of, well, let's give the contract to Bob because Bob's our buddy and one day I might need something, right? That's the fiduciary breach. If it turns out Bob's company or Bob's son's company or whatever it is, if it turns out the company is the best for the job based on the parameters set and the competition out there, then no problem. As long as the board went in with their eyes open and Bob recused and abstained.
Which, by the way, would protect Bob as well from the risk of exposure to personal liability.
In fact, if somebody were to go after Bob and Bob didn't recuse and abstain, Bob would be liable for breach of fiduciary duty. And I tell you this, Bob would be personally liable. Bob would not be able to have the HOA. The HOA would provide a defense until such time as it went to trial and Bob was determined to have been liable. And then guess what the insurance company is going to do is say, pay us back. And that's going to come from the HOA, which means it comes from every one of you guys listening.
Especially if there's a failure to disclose.
That's right.
Yeah.
No, I'm talking about that.
Yeah.
In a situation where it was disclosed, recused, and abstained, and the HOA had other bidding, then Bob's company can be chosen if it's the best one.
That's right. Yeah.
Now, again, there's nothing wrong with hiring Bob's company. What's wrong is Bob doesn't disclose the nature of the conflict, doesn't abstain and recuse, and the HOA or the HOA doesn't look at other similarly situated companies and provide a fair analysis as to what is best,
That's right.
not for Bob, their friend, but for the HOA as a whole. Because they are not Mary, John, Stephanie, and Joseph, and Bob. They are the directors for the HOA. Mm-hmm. And they must wear that hat if they're going to sit in that director chair. So there you go. So those are, we see that in vendor contracts and scenarios. Architectural enforcement bias. Let's give it one. I'm on the board. My buddy, my best friend, my neighbor, who has moved in with me from the beginning of the neighborhood, we've been here the longest, wants this balcony extension. And, we've turned down several balcony extensions of the same sort. But I want Bob to have it, so I'm going to have Bob slide right through the process. I'm going to grease the directorial wheels, or I'm going to have a conversation with one of the committee members. Hey, committee member, you're going to have this application coming through. I want you to, this guy's a good buddy of mine. No, that is illegal.
Can't do.
That is illegal. Friends and allies that are receiving leniency, or special treatment, that is called selective enforcement. We have an entire podcast episode on selective enforcement. It's illegal. You can't do it. It's wrong. Here's another example. Friends or allies receiving lenient treatment for misconduct. Bob has a good friend buddy that lives next door, and that person's getting complaints about leaving their trash cans out, or their dog's always off leash and harassing people, or there's noise, or they party every weekend and there's always complaints and nothing's ever done. But somebody down the street that Bob doesn't like, that person gets a hearing letter and is directed to a hearing for discipline. Okay? No, that's also selective enforcement. You can't do that. You can't do that. Okay? Give me one more. Give me a classic one involving architectural approval in a director.
Well, you may have something you're doing to your own unit, perhaps, and actually something that came to mind, Mike, is a couple of recent ones I've encountered where you're getting repair and maintenance done, and then you're voting on it and using association resources on something where you have the maintenance and repair responsibility.
Let's break that up. Let's break that, because that's two separate ones, and they're both very good. They're both just as good. So let's break that up. Let's go with the first notion that you were just talking about. You are seeking an application to extend your balcony.
Right.
You, Bob, on the board, is seeking to do that. That's a conflict, right?
That is a conflict. So,
and that's not one you have to disclose, because the HOA is going to be aware of it. They know that
clear,
Bob's the owner.
And he ought to be recused, as we established. So assuming it's a corporation, right, it's deemed a corporate entity, he ought to do the higher threshold of not mere abstention from a vote,
if it's a corporation.
Recuse himself, because now he's subject to Corporation Section 310 and 7233.
Yeah.
And so that recusal would be proper, fully extricate himself from deliberations, from any possibility of undue influence on the others deliberating.
No emails to the committee members, no emails to these buddies on the board saying, hey, make this happen, I want this extension. It's got to be granted or denied based on the governing documents and what is in the rules and the architectural guidelines, or whatever, however it is in your HOA. Sometimes it's a CC&R, sometimes it's rules, and sometimes it's a separate document, architectural guidelines. Whatever it is, Bob has to be treated like any other homeowner at large, and not any better or any worse.
Correct.
Period. End of story. Bob shouldn't be involved in that decision in any way, and shouldn't be influencing people, behind the scenes, because that's the opposite of what recusal and abstention are. Well, you could still abstain technically, but you're certainly not recusing.
Right.
Okay. So, assuming your HOA is a corporation, he needs to go to the higher standard. Now, you also raised a separate scenario
I did.
involving Bob. Let's change it from Bob. Let's be fair. Let's have Mary now. Now, Mary's on the board, sits next to Bob at the meetings typically, okay? Mary, give me Mary's scenario that's the other issue.
Let's say it's a condominium complex and Mary has a balcony or some elevated deck feature, and this is exclusive use common area.
The balcony.
So under let's say under their governing documents, Mary's responsible for, simple repair and maintenance, such as the surface of it and sealant, and then if it's anything structural or more intricate, the association has that responsibility.
Right, which is typically the case in a condo. Right.
Now, let's say Mary did something to her balcony component that caused damage or caused a more rapid deterioration of this unit, of this component,
and then goes winding.
And she's responsible under the governing documents and just Davis-Stirling Act. She would be responsible for the repair and replacement of whatever she has caused the damages to. Now she goes to the association, exerts her undue influence on the board, and
even subtly exerts it by just asking.
And she either approves, kind of sua sponte approves a vendor to come out and do the repairs to this balcony unit, kind of flexing her muscles on the board at the cost of the other membership. Members.
As the HOA paying for it.
Yeah, the HOA paying for it.
Let me give you another one.
Or in cases where they just simply tender to insurance too, arguably.
Right, same thing. Yeah. Let me give you another one with Mary. Mary has a condo, same condo, and in front of her building, which has other condos there, but in front of her building, maybe directly underneath where her balcony is, or to the side, she doesn't really, it's a little plain in her taste, and she doesn't really like the way it looks. So she walks over to the landscaper one day and says, "Hey, I'd like you to plant azaleas. This whole area over here. Let's have a couple of hanging vines, and let's do a little trellis and get some flowers on there. I want some color to beautify my building here."
Yeah.
Now, none of the other buildings get the trellis or the azaleas.
Yeah.
For those of you who do your own gardening and go to either Home Depot or a nursery and buy your own flowers and plants, it can be pricey depending on what you're buying. It can be very expensive, especially if you're covering a large area. If you're covering a few thousand square feet of landscape section to cover it in different plants and flowers,
adds up quickly,
it can be very expensive. Yeah. But see, Mary took it upon herself to instruct the landscaping without even going through the board. Mm-hmm. Certainly didn't recuse herself to beautify her building, her little neck of the woods, the part she has to look at every day, at the expense of everybody else. Now, it's nothing wrong with wanting to have flowers and azaleas and a trellis there, but that needs to go through the normal process. The directors as a board need to sit and meet and talk about it, an open meeting, and decide whether or not to expend HOA funds. And if so, it should be done to all similarly situated buildings.
That's right.
Not just Mary's building. But we see this all the time, where directors will either intercede directly with a vendor without going through the board, or they'll exercise their authority on the board to get the board to agree to expend money, but without divulging the fact that it's only going to this one building and to nobody else. And homeowners are left paying for it.
The example you just gave, it's not a mere hypothetical. We
actually have a
case
now.
A board president actually paid a landscaper, a gardener, out-of-pocket cash and then sought reimbursement for that.
That's right.
Simply benefiting her area.
In fact, and this is why when we ask you to exercise your rights under 5200, one of the documents that we always want you to ask for are reimbursement requests, because that's where this stuff shows up. So we have a case right now, he just said, where this director, to the tune of several $1,000s, instructed the landscaper, who is a contractor for the HOA, not her personal landscaper, because this is a condo situation and she doesn't have a personal landscaper, to go and plant all of these flowers and plants, paid for it up front, and then sought reimbursement and received reimbursement from the HOA. And this person was part of the vote. So no recusal, no abstention, no meeting to authorize the spending prior to it happening. That, my friends, is classic conflict of interest. It's a breach of fiduciary duty on her and on the rest of the board. Every one of them. So, perfect example. Let's talk about financial perks and special treatment, okay? Again, and you're going to see trends here. And one of the trends you see with these violations are selective enforcement, because by definition, when you treat one homeowner differently than others, that is selective enforcement, okay? Selective fee waivers, okay? A fee for something is waived, okay? Or reimbursement approvals. The example that you just gave is the classic example. And by the way, we have a current active case, the one he was talking about, Sam was talking about just now. We have that right now, but we've had them in the past too. That's not a new scenario. It just happens to be we have an active one of those right now. But we've had them before and we'll have them again. And so this selective reimbursement approval that's what that is. It's these people who are trying to act like they're paying for it in the moment, but then they behind the scenes go and get reimbursed. So they never paid for it. They did, and then they got reimbursed. Okay? Or directors approving financial benefits for people they like.
Yeah.
Okay? It could be a fee waiver. Some HOAs, depending, usually in the more higher end HOAs where the work being done just by the nature of the properties involved is often very, very expensive, will require a HOA to have a more active role in kind of the management of the project. And so they will charge a management fee, and sometimes it's a deposit, and sometimes it's an actual fee. But in certain bad HOAs in those communities, they waive those because the homeowner that's doing the work not only has to pay the contractor that this person's hiring to the tune of hundreds of thousands of dollars, but also sometimes write a $20,000 or $30,000 check to the HOA. And, maybe this director says, we'll waive it because it's me. We're going to waive that. I don't need to put the fee in. I don't need to put the admin fee because I'll manage it.
Or in cases of waiving insurance deductibles too.
Right.
When there's a loss claim, I mean, if you're being selective and there's disparate treatment, you do it. You charge some pertaining to the way it's structured in your governing documents on certain claims, and then you waive it as to others.
Yeah, you can't do that.
Can't
That's
do that.
Selective enforcement.
No.
Okay, so those are kind of the big three.
Yeah.
Okay, the big three areas, I should say. All right, that's where for the most part you're going to see conflicts arise in an HOA context. So how should directors behave? Well, I think we've kind of talked about it. We'll be official and we'll touch on it, okay? So conflicts of interest arise, as I said. They happen. And nobody has a problem with the fact that they exist and they arise in normal everyday life when nobody's done anything wrong. It's what you do with it once it's recognized or once it's occurred that it makes all the difference in the world, okay? So when a conflict does arise, and they do, a good HOA director is going to take certain actions, okay? They're going to disclose to the board. They're going to recuse from the discussion. They're going to abstain from the vote. And then the remaining disinterested directors are going to discuss in hopefully unfettered by their feelings about how this gal or guy on their board might take it and make a decision that is ultimately in the best interest of the HOA.
Right.
And if that happens to be, we're going to go with that. Bob's company or Bob's friend's company, then so be it.
So be it.
No
Yep.
problem.
Yep.
That's not illegal, unless it turns out Bob's company or Bob's friend's company was not a good company, and in comparison to the others, was outplayed on an apples for apples comparison. And that's the issue. Were there others?
Yeah.
As a director, on that last part, the disinterested directors are going to do the right thing and they're going to abide by fiduciary duties. It implies a bunch of steps. One, they're going to make a decision in good faith. They're going to allow a bidding process. They're going to look at other contenders, make apples for apples comparisons, and then decide on what's best interest financially.
Yeah.
And because it's not always financial. Sometimes it's this person's cheaper, but this person's hasn't been suspended before.
Yeah.
Those are other factors that play into the decision.
Yeah.
There's nothing wrong with if the company they ultimately choose is 10 or 15% more expensive. If that company has a stellar reputation and the cheaper company doesn't, it's a business decision ultimately, and in many cases, in most cases, that would be a good decision probably.
Yeah. Yeah.
So all of that goes into play here. That's how a good HOA and a good HOA board's going to act. Okay, and in other words, to make this very simple, no rubber stamping, folks.
Correct.
HOAs can't rubber stamp. They've got to look at the situation with fresh eyes, disinterested eyes, and then do what's best for everybody. Not what's best for them and not what's best for Bob or Mary, but what's best for the HOA, whatever your HOA is. Okay? It's that decision they make better stand up to scrutiny if it's ever challenged later.
Yeah.
Okay? And if I were on a board, every decision I was involved in would stand up to scrutiny because I would be absolutely ridiculously transparent about everything. So I'd never have to worry. It's so much easier to be transparent because you never have to worry. You can always say, here's the email where I disclosed everything in writing. Here it is.
Right.
And I even commented at an open board meeting to the general population, and I'm attaching to the minutes a copy of my email, so I'm making it available to all my homeowners. Ladies and gentlemen, we're going to be bidding for as you heard, we just voted on this. I disclosed that my son owns that company. I've asked the HOA to open up the bidding process, And if my company gets the contract, great. But to compare us apples to apples and be fair. And if my bid comes back or my son's bid comes back as the fair bid and we get hired, then that's great. I won't be involved in decisions. I've abstained.
Right.
And I've recused.
Be beyond reproach.
You go beyond reproach, you can never get in trouble.
Yeah. Mm-hmm.
Because the law doesn't require the absence of conflict. The law requires that you deal with conflicts ethically. And that's how you do it. So, how should homeowners uncover? Or what should they look for to determine whether or not conflicts exist? Well, to uncover it, they've got to use their right that we talk about in episodes all the time, including in a very specific episode.
There are 5,200 requests.
That's right.
Look at the records, look at the minutes, look at
Grab the minutes.
Reimbursement.
Why the minutes? Because the minutes will talk about what was discussed in open meeting.
Any resolutions that were passed, adopted.
Look at the agendas, right?
Yep.
What else? Look at the vendor contracts. Ask for copies of the contracts.
That's right. Yep.
Okay. Invoices for these vendors.
Mm-hmm.
Okay. Contractors, usually, if you ever had work done, you've hired a contractor, there are certain, there's a payment plan here, right? And certain milestones are hit and a check goes out.
Mm-hmm.
So you have a total for the contract, but it's going to be broken up into, let's say, 3, 5, 7, 8, 9, however many payments based on milestones that are hit.
Yeah.
Look at those invoices because as each milestone is hit, an invoice is going in.
Mm-hmm.
Look to see whether or not, when you add those up, it adds up to the contract price. Have there been change orders? Who voted on it? It'll all be in the minutes. It should be in the agendas.
And the better associations and better boards actually will go a step beyond. They'll have actual narratives and streamlined communication with the membership saying, we chose this over these for these reasons, for the warranty, for the track record.
Right.
We have a continuous
quick email
relationship with this contractor. So they will elaborate, and guess what? They have nothing to hide, right? Nothing to fear, and then you typically see that, and that's captured.
You see that in good HOAs, and there are a lot of good HOAs, and it'll come from the management company often. At the behest of the board has sent the management company certain points and said, hey, send out a thing to everybody. Just keeping everybody apprised of what's going on.
That's right. Yeah.
You want to ask for reimbursement records. You want to ask for bank statements. You want to ask for bids and proposals. You want to ask for executive session agenda descriptions and the brief descriptions in the open meeting minutes. Remember, what happens in executive session is not disclosable to homeowners, but the agendas for executive sessions are, and the summary of what was discussed in executive session is supposed to be part of the regular open meeting minutes.
Short recap, yeah.
Look at those, okay? That's where you're going to see all the stuff that may or may not lead to suspicion. They can't hide it. If you're looking, you will find it, okay? Now, you're going to see from these documents whether or not disclosures occurred, whether or not conflicts have arisen and disclosures occurred. I should have put it in that way. Whether abstention occurred or recusal occurred, because the minutes always tell you who voted. So Bob, Mary, Stephanie, Joe, and Mike attended the meeting. Bob recused himself for the vote, and the voting occurred on the remaining 4.
Yeah.
It'll say that in the minutes if the minutes are done properly. Okay? Whether less obvious is whether or not a decision was made based on an impartial, you're not going to ever know whether or not secret emails were sent privately between. Right. That's something you could get later after you have probable cause to determine whether or not there's an actual conflict. Then you can actually get specific and get other documents, okay? But sometimes you'll spot payment patterns.
Yeah.
If the same vendor is used year after year after year, and there's no open bidding process, that is a hint that something might be at play. That's when you start asking pointed questions. Or you look, who owns this company? You go onto the state contractor's license board, find out who the licensed contractor is and see if it's got the same last name perhaps. Or you look at the corporation, see who the officers or directors are. You start looking at that, or you send an email directly to the manager and to the board saying, hey, I notice that every time we have landscaping, we hire this one company, but I've never seen any evidence. I could be missing it, but I've never seen any evidence of an open bidding process. Can you please confirm whether or not, A, there's been an open bidding process every time, and we decided to go with this vendor because they're the best one, and can you show me documents that evidence that? You're entitled to that, and they have to answer. And if they don't, they're hiding something, because if they do, sure, here. Why do they care? Well, it goes back to, you don't need to know that. You're not on the board. Well, no, you do need to know. You have a right to know, and the director's an idiot. Okay? The red flags are minutes, missing disclosures, or recusal documentation. Okay? If you don't see those, it means they're not there. They're supposed to be there. If they're not there, then either it never happened or the minutes are done badly. Either way, same thing, okay? Because I'm going to assume if it's not there, I'm going to assume you know how to do minutes. So I'm just going to assume it never happened, okay? Contracts repeatedly awarded to the same people, red flag, okay? Selective fee waivers or reimbursements seems to be, we always get we see fee waivers once in a while. It always seems to involve a board member.
Yeah.
Okay? Decisions that benefit a small group as compared to the others. Like only the buildings around the pool, which happen to be buildings that have board members living in them. Okay? That pattern, that's a red flag. Okay? Doesn't always mean that you're going to find something there, but it's a red flag to look. Or gaps in documentation that should exist but don't.
Yeah.
Right? Okay. What do you do with your homeowner and you've caught some of these red flags?
Well, I mean, obviously you're documenting the process, but you make a demand on the board for
in writing.
In writing for an explanation. You can make a demand on them for an IDR to meet and confer with the board, or
if they don't give you a satisfactory answer.
Correct.
Of course.
I mean, you can arguably go a step beyond that and make a demand as part of your IDR process for them to increase disclosures or competitive bidding. Adopt policies, perhaps even, I'll go as far as one more addition that I think is a good practice for a board, for them to adopt a code of conduct and ethics policy if they don't already have one, for the board to be essentially.
Now, let's say that they push back, because a lot of boards will, out of ego, they'll push back.
Sure.
Well, we don't want one of those.
Sure.
A great tool, and we talked about this in a few different episodes, and you'll recall this, is to take your argument, take your stump to the membership. You have a right under as a member of the association, you have a right to the names and addresses of every single fellow member of the HOA. And to the extent that HOA members have not affirmatively opted out, which is most people haven't, you have a right to email addresses to the extent they exist. And we frequently counsel our clients to prepare emails to all of the other members explaining the nature of what's going on. Here's what's happening. Here's what I discovered. Here's what I did, and here was their response.
Yeah.
And it's inappropriate. It's the opposite of what they should be doing. They should be bending over backwards to be transparent, and they're not. They're circling the wagons. That means that I think it's reasonable to assume something's wrong, and I'd like all you to help me apply pressure. Or go further and say, at this point, because of their behavior, I think it's time to try for a recall. So I'm going to be passing a petition around. I'd like y'all to sign it because you only need that 5%. We have an episode on recalls.
Yeah.
Also, numerous articles and fact sheets on my website, mbkchapman.com. Look under the libraries tab. Go to the search bar, type in recall. You'll find a bunch of articles and fact sheets. That's a very powerful tool if you have the time and desire and you want to get your people involved. Now, the smaller the HOA, I think the harder it is to utilize that. Believe it or not, it's counterintuitive.
It is.
Now, last resort, all of that fails. It might be time to come to us at MBK Chapman to do an ADR. Demand is a prerequisite for a lawsuit. If no ADR demand is required and we don't think it would help, we can go right to the lawsuit. But typically, it's worth our sending a demand letter. But it's a formal demand under the auspices of the Davis-Stirling Act, which not only triggers certain due dates, but has consequences if they fail. So it's not just a regular demand. It is a very specific type of ADR demand. And we've got an episode on that as well, a couple of them, okay? So, folks, obviously, HOA has, your board of directors, it's its fiduciary duty to be transparent. That's obvious. Everybody knows that, but that doesn't always happen. The whole point of transparency is to keep everybody informed as to how their money is being spent. And a big part of that is to avoid things that cause conflicts of interest, because by definition, conflicts of interest that are allowed to go unfettered and that remain secret lead to a lot of corruption. So we talked today about how to recognize what a conflict of interest is, what is it under the law, how to recognize it, what the red flags are, and how to deal with it. If your board is engaging in behavior that violates conflict of interest laws that are set forth in the Corporations Code and in the Davis-Stirling Act, then you must act, because a board that's willing to do that is willing to do or cross any line. And it is your investment, it is your property at issue here, and it's ultimately your money. So act in your own best interest and hold your board accountable. If you like this episode, please hit the like button. If you haven't already done so, please subscribe to the channel HOA Hell. If you'd like to leave a question or a comment, we'd love to hear from you. Until next time, have a wonderful day.